I'm Valerie Powers-Smith, and today I want to talk about the other type of special needs trust. In an earlier segment, we talked about the third-party trust that one would put as part of their estate plan, and that trust is one that receives only third-party monies to benefit a person with special needs. The topic for today's discussion is what is often referred to as a first-party, a D4A, or a Medicaid-payback special needs trust. This trust is one that only ever holds or is funded with the assets that belong to or vested in the person who is the beneficiary and has special needs. The way that this type of trust would come into action, some individuals may have a disability that originated from a situation at birth, or they may have a personal injury that resulted in, such as a traumatic brain injury. There may be lawsuits surrounding those two circumstances, at which time it is advisable that whoever is handling it engage an attorney that engages in special needs trust work to make sure that the settlement is directed into that special needs trust. The purpose of that is when funds are in a special needs trust, they are not countable resources for means-tested programs such as SSI and Medicaid, often called medical assistance or Medi-Cal, depending on what jurisdiction you are. There are other means-tested programs such as Section 8 housing or pharmaceutical assistance. So depending on what your circumstances are, it's very important to make sure that you preserve either current or future eligibility. Therefore, a special needs trust will be recommended. The other situation that people often don't think about is when someone accumulates assets during their lifetime because they may be a higher functioning, but later in life there may be a medical condition that creates a situation where they can no longer work as profitable as they did before, or may be more dependent on means-tested programs and long-term care services. There are mechanisms that I can petition a court to ask for the assets to be recognized, for the court to create a special needs trust, and to redirect all funds there. Similarly, it may be a situation, unfortunately, divorce is something that happens in society and is a higher percentage, unfortunately, in the special needs community because of the stress that caring for a special needs child can place. In those circumstances, I know the focus is always on the husband and the wife. I've often been engaged to look at what are the special needs components of this divorce as it applies to the child with disabilities. Often there is child support that is something very important that someone fights to have in place. Child support is something that is counted by the Social Security Administration, 2/3 of which as the income of the child with special needs. People may not think about that because they're thinking it's going to the custodial parent. There are ways to put in place at the time of the property settlement or the marital separation a special needs trust that will receive this child support payments, therefore creating a situation where the income coming in will not be an excess income, and in the month following an excess resource. And so it's important in the situation of a personal injury, a medical malpractice, or even a divorce to make sure you have a D4A, first-party trust, or a Medicaid payback trust in place so that you can preserve the future eligibility or current eligibility and make sure that you can enhance the life of your family member with special needs.